JAL acquisition case. Vedanta gets a setback from the Supreme Court, but why has Adani's 14,535 crore bid not been stayed for now? Imagine this, a company whose name was once taken along with big ambitions in highways, power projects, cement plants, and real estate is today counting its last corporate breaths between courtrooms, creditors, and insolvency files. From the outside, this case looks like just an acquisition battle. Adani Group on one side, Vedanta on the other, and in the middle, debt-ridden Jayaprakash Associates Limited or JAL. But the real story runs much deeper than that. This is not just a fight over who gets the company. It is a fight over the trust on which India's insolvency system stands. And when the Supreme Court itself says that, for now there is no basis to stay Adani's 14,535 crore resolution plan, but at the same time tells the monitoring committee not to take any major policy decision without NCLAT's approval, then it becomes clear that the matter is legal, sensitive, and could become a precedent for corporate India. On the 6th of April 2026, the Supreme Court took exactly this stand on Vedanta's stay plea and asked the NCLAT to hear the matter quickly from the 10th of April. And this is where the suspense begins. Because at first glance, the news looks simple. There is no stay on Adani's bid, which means the path is clear. But in courtroom language, the path is clear and the matter is over are not the same thing. The Supreme Court did not tell Vedanta that its objections are worthless. It only said that, for now, the appellate forum, meaning the NCLAT, is hearing this dispute. The final hearing is listed from the 10th of April, and therefore the top court will not step in and grant a stay at this stage. At the same time, by placing restraint on JAL's monitoring committee, the court also showed that the judges understand the sensitivity of this process. In other words, the message was that Adani's plan will remain effective for now, but the entire process will not go outside judicial radar. Now let us go a little back, because the timeline is very important to understand this story. JAL, which was once counted among the flagship companies of the Jaypee group, had been struggling for a long time with financial distress and debt pressure. During the insolvency process, several bidders entered the field for it. According to available reports, lenders had approved Adani Enterprises 14,535 crore plan in November 2nd, 2025. After that, on the 17th of March 2026, the Allahabad bench of the NCLT approved Adani Enterprises resolution plan. This was the turning point where a boardroom battle became an open legal battlefield. Because Vedanta, which was itself in the race, was clearly not in the mood to accept this outcome. And Vedanta's anger is not only about losing. Its main argument is that it was treated unfairly in the bidding process. According to reporting by PTI and Business Standard, Anil Agarwal publicly claimed that Vedanta had been declared the highest bidder and had even received written communication to that effect, but later the decision was changed. Vedanta has also said that its bid value was higher than Adani's. According to Economic Times reporting, in the NCLAT proceedings, Vedanta's counsel said that its bid value was 16,726 crore, while Adani's bid was 14,535 crore. However, the lender's side has maintained that not just the headline amount, but also the payment structure, certainty, speed of repayment, and implementability of the plan are important. This is exactly the point where insolvency law collides with business arithmetic. This is where the first big question rises in the mind of the ordinary viewer. If Vedanta's bid was higher, then why was Adani preferred? From the outside, this question looks very straightforward. Higher bid means better offer. But under the IBC, while choosing a resolution plan, amount alone is not the decisive factor. The Committee of Creditors, or COSI, looks at many aspects such as net present value, upfront cash, legal certainty, implementation risk, timeline, asset monetization structure, treatment of creditor classes, and future viability. According to available media reports, lenders considered Adani's plan better on the basis that it had stronger features such as upfront cash and faster repayment, while Vedanta challenged this by arguing that ignoring the higher value offer goes against the principle of maximum recovery. This is where the matter becomes not just corporate rivalry, but an issue of IBC jurisprudence. On the 24th of March 2026, before the NCLAT, Vedanta challenged the NCLT order and sought an interim stay. Its demand was simple. Until the appeal is decided, the implementation of Adani's plan should be stayed. But on that day, the NCLAT refused to grant any interim stay. The tribunal asked the COSI to file its reply and listed the matter for further hearing on the 10th of April. This refusal was a major setback for Vedanta, because it meant that the process on Adani's resolution plan was not stopping. The very next day, on the 25th of March, Vedanta reached the Supreme Court. That meant the matter had now moved out of the insolvency bench and in front of the country's highest court, and the narrative had become even more high stakes. But what the Supreme Court did was perhaps the most interesting legal moment in this case. The court gave neither full relief nor full rejection. It did not stay Adani's plan, which means it refused Vedanta's immediate demand. But at the same time, it also restricted the monitoring committee by saying that no major policy decision should be taken without prior approval from the NCLAT. What this means is that the Supreme Court showed trust in the lower appellate process, but did not adopt a completely hands-off approach either. In a way, the court said, "We are not stopping the process right now, but we also do not want the appeal to become meaningless. This kind of judicial balancing act matters a lot in corporate litigation, because many times if implementation moves too far ahead, then even if the appeal is technically pending, it can become practically infructuous. Now understand JAL's corporate significance. JAL is not some small distressed company. It has been that entity of the Jaypee group with which assets in cement, real estate, engineering, hospitality, and infrastructure have all been linked. According to Money Control's reporting, home buyers' claims of around 2,074 crore are also included in the plan approved by the NCLT. That means this matter is not limited only to a bidding war between large industrial groups. Banks, financial institutions, operational creditors, employees, and home buyers are also connected to it in one form or another. So whatever final decision comes, its effect will not be limited only to the reputation of two corporate houses, but will also impact the recovery and future of many stakeholder groups. This is where the human layer also enters the story. When we hear acquisition battle, usually only big names like Gautam Adani and Anil Agarwal come before us. But the real ground of insolvency cases lies somewhere else. There are banks' balance sheets there, lenders' provisioning there, workers stuck in projects there, suppliers' unpaid dues there, and homebuyers' life savings stuck there. That is why Vedanta's objection cannot be dismissed merely as a corporate ego battle, and Adani's victory cannot be called just a boardroom victory either. Behind both are claims worth thousands of crores and the hopes of many affected stakeholders. That is exactly why the Supreme Court also did not dispose of this matter casually, but kept the process under watch and signaled prompt hearing before the NCLAT. There is another deeper point hidden in Vedanta's legal strategy. It is not saying only that its bid was larger. Its broader complaint is that there was a lack of transparency and fairness in the approval process. This is a serious question for the IBC framework, because the entire philosophy of insolvency law rests on the idea that distressed assets should be resolved through an orderly, transparent, and value-maximizing process. If the losing bidder begins openly saying that it first received a communication declaring it the winner and then the result was reversed, then naturally a trust deficit is created. On the other side, the lenders and the winning bidder say that courts can review the commercial wisdom of the COSI only within a very limited scope. This is the legal tug-of-war that is now set to sharpen before the NCLAT. And that is why this matter has started looking like a test case for India's insolvency ecosystem. Over the last few years, the picture around the IBC has been mixed. On one hand, it brought many deadlocked assets onto the path of resolution, improved bank recovery discipline, and to some extent checked promoter impunity. On the other hand, delays, litigation, valuation disputes, low recovery ratios, and procedural controversies have also come out. In a large case like JAL, if the appellate tribunal clearly explains why a lower bid was preferred over a higher bid, what the limits of commercial wisdom are, what the legal value of bidder communication is, and what safeguards are necessary during monitoring, then it may act like a precedent for many large insolvency cases to come. For the Adani Group too, this case is not just an acquisition. In the assets of a stressed company like JAL, there are many strategic angles such as cement linkage, real estate value, land parcels, infrastructure synergies, and legacy project potential. Over the past few years, Adani has expanded aggressively across energy, ports, airports, logistics, cement, and infrastructure. In that context, the JAL acquisition fits into the group's broader integration logic. That is why not getting a stay from the Supreme Court is certainly a tactical relief for Adani. But final certainty will not come until the NCLAT disposes of the appeal. In the corporate world, many times temporary victory becomes the headline, while the real fight gets decided in the detailed hearing. In this case too, that is the stage now in front of us. For Vedanta, this setback is both symbolic and strategic. Symbolic because not getting an immediate say from the top court affects market perception. Strategic because now it will have to frame its challenge before the NCLAT very sharply. It will have to show that not only was its bid amount higher, but there was such a legal infirmity in the process that the approved resolution plan itself becomes vulnerable. If it fails to show this, Adani's position will become even stronger. But if it succeeds in convincing the tribunal that the process was not law compliant, or that the COSI's decision cannot withstand judicial scrutiny, then the entire resolution exercise could be shaken again. It is this possibility that has made the litigation so dramatic. Another interesting aspect is that the Supreme Court itself has not commented on the final merits. This is very important. It means that even if the media headline says Vedanta gets a setback, the legal position is still open. The court has only denied interim relief, not given final adjudication. In Indian corporate litigation, this nuance often gets lost. Public perception starts assuming that the party which won the interim round has won the whole case, whereas the reality is that appellate forums may reach a different conclusion after looking at the final record, process documents, bid evaluation criteria, committee minutes, and legal compliance. That is why the 10th of April NCLAT hearing is not just a procedural date, but may become the truly decisive stage of this battle. This entire dispute will also have a big effect on confidence in corporate India. When bidders enter the race for distressed assets, they need trust not only in asset quality, but also in process quality. If bidders begin to feel that the challenge process is opaque, the winning declaration is uncertain, or litigation after approval is endless, then future bids may become conservative.
On the other hand, creditors want courts not to microscopically reevaluate their commercial decisions too much. Otherwise, the insolvency process itself will freeze. That is why the JAL case is fundamentally a case about this tension. Speed versus scrutiny, commercial wisdom versus legal fairness, finality versus judicial correction. And that is exactly why this case has become not just the story of Jaypee, Adani or Vedanta, but the story of the credibility of modern Indian insolvency architecture.
If this video has taught you something new, or if you feel this information should reach more people, don't forget to like and share the video. Your small share can become valuable and useful information for someone else. If you have any questions related to this topic, or if you would like to share your opinion with us, be sure to write in the comment box. We read every question and suggestion from you, because your feedback inspires us to create better content. And if you want to keep receiving such interesting and reliable information about business, the economy, and the world in the future, then don't forget to subscribe to our channel GRT Business and also press the bell icon so that you get notifications of every new video directly. At GRT Business, we always strive to provide you with accurate, balanced, and reliable information. Our news and analysis are prepared based on information obtained from various news agencies, public sources, and public opinion. We make every effort to verify and validate each fact as much as possible, but in case of any possible error or dispute, the responsibility lies with the respective sources. Our only aim is to present you with a correct and trustworthy perspective so that you can understand any topic better.